Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by the founder of Monkhouse Law, appropriately named there. Thank you so much, Andrew Monkhouse, here for joining us and talk to you about employment law, your practice, as well as getting started setting up your own practice right from the beginning. So, thanks so much for joining us here today, and perhaps maybe you can tell us a little bit about yourself and Monkhouse Law.
Hi, thanks for having me. I was happy to be invited along. As was mentioned, I'm a lawyer in Toronto. Monkhouse Law does mostly employment law, so helping about 80% employees, 20% employers in terms of their employment issues. A lot of that's negotiating severance packages, but helping with all types of issues. And we also have a growing class action division where we assist employees who have had problems on a class-wide basis, say misclassification or underpayment of funds. And that's been a growing area. At present, we have the most misclassification, well, actually the most employment class actions of any law firm in Canada. It's a growing area in Canada, and we're leading the way on that. But we do represent a lot of individual employees, and we do represent some small and medium-sized businesses, and assisting them with the issues, especially litigation. I pride myself on being a litigation lawyer. I've done a large number of trials and motions, as well as representing on class actions. So that's something that I really enjoy.
So I think very interesting, after the people complete law school and then the article, and then maybe they go and work as an associate for a few years, but that wasn't the case for you. What kind of led you to say, look, I'm ready to start my own practice right out the gate? What kind of went into that decision-making process?
It's a great question. There's probably, like everything in life, a number of answers to it. So we're trying to distill it down, though. Realistically, I'd had a very good experience. I'd run student government, and that was a great experience in managing people. So I liked that. I wanted to be my own boss, to go out and change my own, move my own way. But also, I thought that the market at the time really was missing a sort of custom touch. A lot of employee side lawyers weren't providing what I felt was a great experience at the moment. They were taking people's money and not providing a lot of reward. And so we were able to get into that niche. But I had that experience. I had been a summer student at a smaller firm, and then an articling student at a larger firm that focused on employment. So I'd seen both sides already. Certainly, I don't tend to recommend people going out on their own. It worked for me, but I'm sort of the exception. I coach a lot of people, and not as many people. It hasn't really been successful. You need a lot of things to go right, and so it's with the availability heuristic. You see one person who goes out on their own. It's a tough slog, but we managed to get lucky a number of times in a row, and it worked out well for us. But it can be stressful.
So you said, wouldn't necessarily recommend it, but for those, maybe not right away that do go out on their own, what are the things that you kind of looked at right from the beginning? And if you could go back to, a younger Andrew and say, hey, here's what you should expect over the next couple of years, something, you may do a little bit differently. If there is anything you would do differently, what advice would you share for those looking to start their own practice?
For those looking to start their own practice, you need to come up with a way of getting clients or paid work. You have to come up with a lot of ways. The vast majority of them won't work out, but one or two of them will work out. So different ways of advertising, different ways that you might have clients coming in the door. It's the pipeline of clients that matters. That's very important. And I think that you need to really figure that out. If you have people walking in the door, then the rest puts itself together. And you have to think about how someone who's looking for the legal service you're providing, what they are looking for. It's not my area, but to use an example, landlord tenant, it's a problem perhaps if you're going to be trying to focus on tenants, or it can be because there are structural issues. For instance, the tenant is not paying rent. It is not because they have a surplus of money. So it's difficult. You have to find a way to get in there. And it's the same in our area in employment law. People who are terminated are very concerned about their money. People don't save up for being terminated to fund a wrongful dismissal lawsuit. The average person doesn't do that. So you have to figure out a way to make what you're trying to help people with work with their needs in terms of getting access to justice. So I think that's, something you have to think about. I don't know if I went back to myself in in the past, I'd probably try and give more practical advice, memorize the Super Bowl touchdowns or something like that, buy Bitcoin, or, not keep it. It has no value, but temporarily it would work well. But anyway, that's an aside. I think, just trying to think of the most ways that you can. Now, that's something I did. But I think that everybody needs to do that. It's very difficult to start your own business, partially because people often just don't get a lot of clients, and different people have different advertising advantages or disadvantages. One thing is for paralegals, it's a bit difficult, for instance, for paralegals directly to market themselves just based on how the system works, because when people say get terminated, they don't say go hire a licensee of the Law Society of Ontario. Unfortunately, or fortunately, but unfortunately, they say go hire a lawyer. And that's a marketing hurdle that paralegals need to surmount. And it can be difficult. So you need to think of those types of things. How do you differentiate yourself? How do you get that word out about what you're going to do?
Now, Andrew, I mean, on that point, with the small claims limit going up to 35,000, and I know I have some paralegal students, I have some Osgood students that I'm working with. So, you have law and paralegal students that you're talking to. So, are you seeing any difference there in terms of, because of that extra 10,000, that there are some matters that now go to small claims court that, when you're looking at, the wrongful dismissal, if it's now like 3 months or 6 months, or do you still go through like the simplified procedure in Superior Court if it's going to be under 100,000? Have you noticed any kind of change in the last year and a half since that change came about?
It's a good question. I don't think there's been much change. 25,000 versus 35,000 as an initial ask when you're starting a claim, they're pretty close to each other. It's not a huge change that way. There's more cases where we can feel better about taking them in small claims court because we won't have to reduce the claim. If a claim was sort of for 30,000, you might have thought to reduce it down to 25 and bring it in small claims court before. Now you don't have to make that reduction. The problem with small claims court is that it has been strategic and systematic issues during the pandemic, where effectively small claims court's been closed. The Superior Court is moving slowly, but almost normally. I mean, normally slow. So it's moving almost normally, and small claims court is effectively not moving at all. There's a number of reasons for that, mostly to do with the fact that they have deputy judges who aren't full-time, and so there's less capacity, and the pandemic has just really hit small claims court very hard. We'll see how that goes. This is being obviously filmed in the middle of a pandemic, so we don't really necessarily know how we're going to get out of that. But right now, small claims court, unfortunately, if you would have started a small claims court and a Superior Court action in March of 2020, the Superior Court action would likely have went to trial by now, and the small claims court action would most likely not even be booked for a settlement conference. Sorry, it's something, it's unfortunate, but it's the reality of the situation at the moment.
Well, it's interesting because I mean, I would think maybe in normal times it might have been the reverse, but maybe you can expand there on your, since you're doing quite a lot of litigation there, the effect of the pandemic and how are things being done differently now, and what you've liked about it, what you maybe struggled with in the Zoom, Microsoft Teams kind of era of trials and motions. What's been good, what's been bad, what you'd like to stick around, what would you like to return to?
That's a good question. I think that some parts of the process, for instance, the Superior Court mediations being virtual is very useful. A lot of companies, we represent employees often. A lot of companies, the final decision even for Canadian employees is often being made in the United States. And if you're having a virtual mediation, it makes it easier for that direct decision maker to be a part of the mediation earlier on in the process. Very often before, people would have to, you'd have negotiation, and then you'd have to make a phone call. And then that person is being brought in and told they want to go above the envelope that they want to pay, and here's the reason why. But if they're there from the beginning, it's easier. So virtual mediation appear to be at least equally good, if not better. And there's all sorts of advantages. You don't have to go to one place, and you have your own comforts. So that's been positive. Court has functioned. It's not as good as it has been. It's not as good as being there and being able to flip to the same page and have judges say, well, is that page 70 of the PDF or 70 on the document? And you're trying to sort of cross-reference it. There are difficulties with that standardization process. I can't think of a case where the result is different. I think that the results are going to be the same, but the fact of the matter is there's a part that's not quite working. You have to deal with, you're doing submissions and one of the judges, the judge freezes, well, just because something happens with their internet and it's uncontrollable. You can't have so many backups. It doesn't happen as much in person. I mean, in person you would have that, but less frequent, fire alarm or whatever. But so I think certainly more virtual as an option is going to be good. But I think some certain things we're going to want to have to go back in person. But now that people are willing to do things they would never do virtually in the past, and now they're willing to do them. So that's great. Things like examinations, things like mediations. I think that lots of people are going to be agreeable if the other side wants to doing that in the future when they wouldn't be before.
Now, on that pandemic, I'm sure your entire practice, in terms of clients coming in with all related issues, whether it's vaccinations and negative tests and working from home, anything maybe from over the last while there that I know you said before we started here, there's a lot of questions about what that entails, and now we're kind of at potentially this fourth wave, or potentially everything's going to be fine, and employers are going to want perhaps some of their employees going back in person. Is there, if someone wants to keep working from home and the answer is like, well, hey, everything's been fine working from home, I don't really want to go back. Is there an option there, or are they kind of still at the mercy of the employer? And then I guess we'll start with that, because that follow-up is going to be about the vaccinations and all those questions you've been getting about that.
The law 101 basics with return to work, your employer is allowed to require you to return to work. The thing that a lot of employers are doing though is they're giving people options, and they're saying you can continue to work from home or you can work from the office, but working from home means a certain deduction in your wages. That's what some of them are doing. It's case by case. Your employer can require you to go back to work. And it's not constructive dismissal. But it's really short-sighted. And from what I can see, not a legal aspect, but a human resources aspect, is you'll lose a ton of people. There's already a wave of resignations as we see it. A lot of people they use the pandemic to explore what they care about in life. And perhaps it doesn't involve their current job. And so, we expect that there's going to be a fair amount of people leaving and going to new jobs. So for a variety of reasons. So I guess, you can force people to come back into the office, or at least you can tell them they have to. But that might lose you good people, and it might not be worth it. And then, for the employees, it's about, considering how much you value working from home versus working from the office. Most are going to end up somewhere in the middle, I think, at least in the short term.
And what about, I guess, in terms of balancing that safety with people perhaps having I think the numbers are probably over 80%, I think, the last I checked. But what about these policies now? I know the government says, look, we want to have vaccine passports. I think they're rolling out very soon. What can you do there in terms of if you aren't vaccinated, or you can't, or you're concerned about customers potentially being there that aren't? Is there anything from an employee's perspective that they have to be concerned about?
Well, so in Ontario, this would generally fall within work refusals. So an employee is not required to do anything dangerous. And if they're asked to do something dangerous, then they can refuse work. They can say, I won't do that work. But the government has been very reluctant to uphold almost any COVID-related work refusals. Effectively, if your employer is providing appropriate PPE, really almost any level of PPE, it's considered that you should work. Just getting that working might have you interact with someone who could get you sick has not been upheld as a danger. So, that's something in terms of that aspect. But, in terms of vaccinations, really what we're seeing right now is a lot of mandatory vaccination discussion, employers implementing mandatory vaccination. That being said, mandatory vaccination in effect appears to be changing to a definition of mandatory. I'm going to put some air quotes here, means either get vaccinated or be tested once or twice a week. But this is an ongoing rolling issue. But perhaps in the future, employers, we're seeing more employers starting to put in their contract that when they hire people, that those people have to get vaccinations in the future if, the government recommends vaccination. It's something that people didn't think of before. And so since it's not in a contract, it becomes an area of difficulty if an employee doesn't want to get a vaccination, because while you can say mandatory vaccination, you can't actually live in a free country. You can't actually force someone to be vaccinated. You can terminate them for any reason you want, as long as it's not discriminatory. So you can terminate them as long as it's not discriminatory. So let's say vaccinations is against their religion or against they have a disability or medical reason why they can't be vaccinated. But outside of those two, you can terminate someone. You just have to pay them severance, most likely, which means it's going to be very expensive for a company to do that. So those are sort of the considerations that we're dealing with. But in employment law, there are a lot of considerations. We received a lot of calls. The government invented a new wage subsidy scheme under the, called the CERB or CHRB. We suddenly were overloaded with calls about that. Can I apply? Can I not apply? How does it affect my job, et cetera, et cetera. So, the pandemic has been very busy in that way.
Yeah, I think that's interesting because, effectively the government was saying, here's, I think it's like $900 or so biweekly. If, you qualify. And then if you're going to apply for a job that's going to pay you like $950 or $1,000 biweekly, it's kind of a disincentive. So is there any kind of, I don't know, you just brought it up there. Is there any kind of restriction on that? Like, do you have to be, is it kind of like the old, with EI, you'd have to be actively looking and applying for work and you can't turn down opportunities, or, is there anything that
there wasn't for CHRB. CHRB's over with now. So there wasn't for CHRB. But the confusing thing was, for instance, for like students, did they count if you weren't terminated, but you had worked last year? If you, for instance, a lot of students were caught in a situation where they had expected that they would have been earning money throughout the summer of 2020 or 2021, but their summer jobs were suddenly canceled. But they had earned enough money in the previous year, but they weren't terminated. They were in school, so they were just never hired back. Did they get to apply or not? Small business owners, effectively small business owners, did they get to apply or not? And was it gross versus net revenue? If you made, $7,000 last year, but you had expenses of $6,000, were you eligible or not? And these sorts of things were completely unclear because they built the whole process while they were, it was like building an airplane while flying it. It was just sort of done. And, the issues where people, went on CHRB, and CHRB used up their time for EI, and then they went off on maternity leave, and then they weren't able to get EI during maternity leave because we've triple compiled it. So we had a system of employment insurance. And on top of that system of employment insurance, we decided to shove in a system of maternity leave. Like, you don't have to have maternity leave through employment insurance, but Canada's chosen to do so. Many other countries don't. That's a normal way to do it, but they chose to combine the two. So they're the same. And then on top of that, then you created a second system on a CHRB, and then the relationship between the three, you end up with people in unfortunate situations and all of a sudden saying, why don't I get maternity pay, even though, other people in my circumstance normally would have? So there's a lot of people who are disproportionately affected that had to sort of work their way through the system.
Great. Now, one of the things we were just discussing before, you were talking about class actions there, is often companies, maybe not often, but sometimes companies choose to say, well, you're not employed by us, you're an independent contractor, and as such, we don't have to pay you this, and you're not entitled to terminate. We can just let you go at the end of the contract. Maybe you can clarify, kind of where this sort of, if it looks like a duck, quacks like a duck, we call it a duck. Is it in fact still an independent contractor if we treat you all otherwise as an employee?
Yeah, it's what actually, for misclassification, it's how the actual relationship is. There's a number of factors, but the real question is whose business is it? And the fact of the matter is, what's actually on the piece of paper is virtually irrelevant. In fact, it's not one of the considerations. The intention of the parties or what's on the piece of paper is irrelevant under the employment standards. It is in the Employment Standards Act that employers are not supposed to misclassify employees, so they're breaking the law if they do so. So, generally, it is the actual work in question and whose business that that company is. The person in the business of supplying their own business, or are they in the actual business of a larger company? And that's where class actions come in to try and sort this out on a large basis. Luckily enough, Canada's hopefully move towards that. The United States is ahead of us on that, but more and more misclassification cases are moving ahead in Canada, where hopefully that's going to create a chilling effect. Unfortunately, at the moment, there appears to be sort of an advantage to companies to misclassify their workers. And so that's why companies do it. They're not necessarily doing it because they care about flexibility. You can have an employee who's just as flexible as a contractor. It's just that they don't have to pay EI, they don't pay CCPP, they don't need to withhold deductions at source. There's a whole bunch of things, but the Canadian system has created a perverse incentive for employers to misclassify their workers, which actually creates a very unfair competitive environment. So if you have the example, if you have Uber's a classic example. If you have Uber that misclassifies its workers, but you have another equivalent of Uber that doesn't, the one that misclassifies its workers is going to have a strategic advantage month over month over the one that's including it's paying its workers correctly and counting them as employees, even though the work of the employees is virtually the same. There's no reason why it would have to be any different between the two. You can have a flexible employee, you can have an inflexible contractor, or at least under tax law you can. The inflexible contractor, we say, actually is an employee and should be paid that money. But that's sort of, I guess, in a nutshell, misclassification cases.
And then you would just look at kind of the relationship to see, how much independence, if any, they have. And that's essentially what the cases would rest on. And then if it's a class action, then you'd look at overall the people affected. Is that kind of what it is? Or maybe you can kind of clarify.
Yes. Well, I mean, this has been a fight in Canada. So anyway, so you look at a large number of factors when determining if someone is an employee or an independent contractor. Technically, to answer the question of whose business is it, who supplies the tools, do they have an opportunity for profit and loss, et cetera, et cetera. For many years in Canada, this made people think that meant that you weren't going to be able to start class actions about it because the company sort of treats people a bit differently. How do you deal with that, right? Maybe someone brings some supplies, someone doesn't bring supplies. And we start going in the nitty gritty, it's hard to determine that. But what we've been able to do in Canada is change it to the main question of whose business is it? And because the courts have recognized that you can structure the question that way, that's a question that can be dealt with on a class-wide basis. Whose business is it? And so by restructuring the question and not so much focusing on the individual questions, how much profit and loss people have, their control, what they do, the elements of supervision, which are all more difficult to prove on a individual basis, by focusing instead on the business structure, it lets us have class actions. And that's where we've gotten to. The first misclassification case in Ontario was in 2015. Actually, fairly recently. We've started that. That was against Deloitte with use of independent contractors, lawyers who are independent contractors. There's been obviously a very large number of misclassification cases since. It's been a growing area. But, these are sort of the considerations you have to look at.
I know you said you're about 80% kind of employee side, and is it mostly you're looking at cases of wrongful dismissal and perhaps now these misclassification cases, or what are some of the different areas within employment law that you do that maybe, I mean, it's such a wide area that I think you could even specialize in certain areas in employment law that students can look at in terms of potential work in the future.
Yeah, you probably could. Yeah, it's interesting. Yeah, the misclassification cases are usually still wrongful dismissal cases. Um, if a contractor is being misclassified by their employer, but the work is going fine, they usually don't sue. That usually happens when the employment relationship ends one way or the other. Um, generally there's sort of three types of law firms, I guess, in employment law. There are management side firms that do almost exclusively management side work. They do labor and employment. Labor in this instance means unionized workers. Employment meaning non-unionized workers. That's how we distinguish it in the area. So big management side firms, they're usually fairly large and they do all management side work exclusively, effectively. Then there's union side firms. They represent almost exclusively unions and they do mostly labor. They also do some individual employee work, but usually would do very, very little, if any, work for employers. And then there's sort of the mixed grouping in the middle of the sort of non-unionized work. So, we effectively do very little unionized work. We do some unionized work for our employer clients, but we won't represent unionized workers, but we represent mostly employees. So it's mostly litigation, a lot of it's severance package negotiation, but we're in the middle ground where we represent both employees and we represent employers, mostly for non-unionized work as well as for employers' unionized work. So, there's a number of firms that are in that middle, and that's been sort of a growing middle grouping that's sort of outside of the typical labor factor. So, I mean, there are a number of areas in employment, but wrongful dismissal tends to be the main aspect in Canada in terms of that's what most people do. There's also WSIB, obviously, the workplace insurance. That's an area that is done by people, lawyers as well as paralegals. But usually that's sort of a division of how the firms work, and people tend to work fairly similarly to that.
Great. Now, and in terms of wrongful dismissal, maybe kind of like a employment 101. What are kind of the general things that you're looking at? I mean, is it simply well, let's go to the as long as it's a not with cause. Like, is it simply here are the factors from Bardal, and they'll have their case law, and that's kind of how it would progress, or maybe it's a little bit more complicated, perhaps, where you can share here with the students kind of what a wrongful dismissal case would look like.
Sure. I mean, the two most important things that affect what someone's going to get in a wrongful dismissal case are whether or not there's a clause in the employment contract that limits how much they're going to get, and then second of all, whether or not they're terminated allegedly for cause. So whether or not they've been given no severance when they've been terminated, or if it's just a straight up negotiation. After that, those two things, and because it's possible for you to contract out of reasonable common law notice, so to contract to a shorter period of notice, so it depends on what's in the contract. But if you don't have a clause, if you have a clause or if cause has been alleged, then you're usually fighting those two things. You're saying the clause isn't valid, or you're saying that there isn't just cause to terminate the person. Assuming you get past those two, you get into reasonable common law notice, which is what you mentioned from Bardal. Approximately, employees tend to get between 3 and 5 weeks per year of service in Canada, with a minimum usually around 3 months and a maximum usually ending up around 24 months. Exceptional circumstances can push it past those limits. So even someone who's worked for 2 days, if they don't have a probationary period, could get 3 months notice easily. And someone who's been working for 40 years, might well still get 24 months notice, if not just a bit longer. So usually you look at similar cases. That's probably the easiest part. But at the end of the day, most terminations in Canada are negotiations, insofar as the employer understands and expects that probably the employee is going to go out, seek legal counsel and negotiate. I say to seek legal counsel because notwithstanding the fact that, I could probably teach you the law, the fact of the matter is what we see is that employers don't really deal with individuals well. They see them trying to negotiate as being insubordination. They don't take you seriously. It's the consequence for them that they're worried about is you going to court and getting a judgment against them. And it's just extremely unlikely that an individual is going to be able to do that themselves. And so that's why bringing in, a lawyer is what is by far better for these individuals. It brings in a third party. They don't have to be fighting with their employer anymore. And there's a whole bunch of super technical parts in the process, what mediator to use, how to move things forward. A lot of cases are able to be dealt with by negotiation. More than 99% of cases settle because both the people on the plaintiff side, the lawyers on the plaintiff side and the lawyers on the defendant side and the company, they understand the risks involved. So that's why most cases tend to settle. But, there's certain strategies you can use to put yourself in a much better position that your lawyers can help with in terms of, say, structuring deals or making sure that they're tax advantageous or maximizing what you're getting. There's a lot of ways in which people can be tricked who are going into it themselves, and so they generally aren't successful. But it is a negotiation. A company that lets someone go and offers them a package, that is not their best offer. I've never seen it be their best offer. They know how the game is played. The pre-owned salesperson who's selling you a car, he doesn't offer you the best price on the car right away. I mean, that's not how it works, right? Canadians are somewhat used to not negotiate. You don't go and negotiate the price of milk. The cashier would look at you oddly, but this is one of those instances. Like if you're on vacation in certain countries, it's very common to negotiate to purchase things. This is one of those circumstances, but the employees often fall into traps in that negotiation if they're doing it themselves.
And that's probably where, they shouldn't be signing off on any release that they get at the time and take it to get some independent legal advice. Probably falls into that category, right?
Well, exactly. And we certainly, one of the things we do is provide summary legal information on the phone. And it's been one of the things that's, become much more common. I said it wasn't common when I started, but we do provide that. So we give people an idea, is there some value in sort of going ahead without them having to, them put all the money forward and, have that sort of dealt with. And so that's one of the innovations that we've had that's really helped out.
Yeah, you mentioned access to justice there, and certainly how someone that's lost the job, and as you mentioned as well, often people are not very, as much as we'd like to be equipped for a sudden abrupt loss of income. How do you kind of balance that in terms of obviously running a practice and needing to get revenue coming in, especially where you've grown to having so many associate lawyers and paralegals working? How do you kind of find that ground there with respect to providing services and at the same time making sure that you're going to collect from each potential client?
Well, because we're more established, we can push files forward and not get paid for longer on them. We tend to defer our fees until the matter is resolved. These people have money coming to them. It's just coming to them at a later point for the vast majority. So because we have a large volume of people, we can get paid now on files that were started a year ago and then not get paid on the file that we're starting now until, 8 months, a year from now as well, or sometimes even later. I mean, we've certainly had files that have been going on for, probably 8 years at this point. So, that's something that really happens. And that deferring the fees is something that we do. And you can't do it in every instance. It's not appropriate in every instance, but we do manage to do that when people are terminated, often when people are terminated from their job. And it is something that does really add to access to justice in that way.
Great. And I think obviously if you're starting an employment-based practice, it's something to keep in mind that you may not be getting a lot of revenue until a year or so later.
I think that's true. I mean, that's many practices though, right? I mean, if personal injury, I think that the timeframes are even longer. I mean, yes, class actions, for instance, it's even worse. I mean, probably the average class action takes 10 years in Ontario. so it would be virtually impossible to set up a class action only practice. You wouldn't have money coming in for quite possibly an extremely long period of time, which is why we were able to, sort of build off of our existing knowledge of employment and employment of assisting employees to be able to build that class action practice. That being said, it is something where, employment, the majority of cases settle within, say, 6 months or so. So, it's a while, but it's not forever, in those sorts of circumstances.
Great. So I want to spend the last little bit of time here. I know, you've organized the Osgood Cup there. Probably the biggest undergraduate and college mooting competition. Maybe you could tell us a little bit about it and mooting in general. I mean, it's something certainly in the last couple of years I've tried to get more of my students to participate, and perhaps you can tell us all about it and where it came from and how it's been going, and certainly doing it this past year virtually. And I think it's a great asset for future potential law students and potential lawyers to hone their skills while they're still in undergrad and college.
Sure. Yeah. So, I mean, the Osgood Cup initially started when then Dean Monahan, now Justice Monahan, decided to create mooting as a concept for undergraduate students. Before that, there hadn't been undergraduate students effectively weren't doing moots. I believe it was 2005 approximately. And he, at the time, Dean of Osgood Hall Law School, said, let's have a mooting competition of undergraduates. A lot of people didn't think that they could do that. And they wouldn't be able to take law students. And but he said, let's try. And he organized the first Osgood Cup. And then the Osgood Hall ran a number of Osgood Cups, one of which I competed in as an undergraduate myself. And I enjoyed it, and then ended up working with people who were running it. For instance, Gina Alexandris is now at the LPP program at Ryerson, and having really enjoying it. I ended up going to Osgood partially for that. I mean, I had a great experience, but liked the school. While I was at Osgood, though, there was a switch. Dean Monahan joined received further promotions, and a new dean came in. And the problem was at that point that Osgood was running the event, but it was quite expensive and onerous for them to run, and they needed to use that money for other things. And so myself and some other students at that point agreed to take on running the Osgood Cup from a student perspective, with the idea that we wouldn't be asking Osgood for money anymore. And that was under then Dean Sawson, now Justice Sawson. And so that was when it sort of became, at that point, run by this sort of group of committee, and I'm sort of the last one standing. We have additional students come in and help with the Osgood Cup. We're dealing with the Mooting Society, but I sort of had made that promise to Justice Sawson to make sure things were running okay. This year, unfortunately, we had to move online, like everything had to. We managed to have the last in-person cup in early March of 2020, when we still thought it was totally publicly acceptable to have 300 people in a room. Nobody saw a problem with that. 2 weeks later, it was against the law. So it's interesting to look back at it now. So that's, I guess, just like a small history behind the Osgood Cup, and it's growing. It's also created a lot of other cups. So it was the first cup, but now, the Capital Cup, for instance, that's run at Carleton University, where actually, by coincidence, I did my undergraduate. I had nothing to do with starting the Capital Cup, but they replicated a lot of what was good with the Osgood Cup, and they run a cup now. And there's there have been paralegal cups, there have been U of T cups, there's Miguel cups. So there's a lot of undergraduate cups now, and so it's a real circuit is developing, and it's really interesting to see that. I did debating back in the day, but there's almost a parallel circuit of mooting as a concept. And one of the things that mooting is something you do in law school, and we've seen and heard that law school mooting is getting more competitive because people are starting earlier. People are starting to train in undergrad, and you're having these extremely well-trained undergraduate students then competing in moots at law school. So it's interesting how it sort of moves up the system. But mooting, for those who don't know, it has an odd name. I agree. But there's no better name that people come up with. Lawyer trial skills, not helpful. You're running a fake appeal as a lawyer in front of judges, acting as if they're at an appeal. And this is a huge advantage over mock trials, which are awful ideas. The problem with a mock trial is you can't have consistent witnesses. You can't have consistent evidence. They do have some mock trials in law school. They're very hard to coordinate, and they're very hard to compare person to person. It's very difficult to decide who's the winner of a mock trial because the evidence goes in differently each time. The witnesses say different things. You can't control that so much. Whereas an appeal, because all the evidence is in already, you are able to do the skills of being part of an appeal, and you can compare people one-to-one and how they argue much better. But interestingly about mooting, it's a effectively controlled discussion or perhaps argument between the competitor and the person who's judging them, because the judges are judging them, but they're also asking them questions at the same time. So that's what's really interesting about it. It's sort of a cross between a speech and a dissertation where someone's presenting, but then they're peppered with questions by the judges. So you don't get to finish. You have to have a conversation with the people across from you, unlike, say, in debate, where you have 7 minutes. You might have to answer one question, but you can otherwise say what you want. You can't just say what you want. You have to work with them, which is very reminiscent of how it actually works, at courts of appeal or at motions court, which is the vast majority of the work for lawyers nowadays, is the vast majority of arguments that take place in front of judges or masters are without witnesses, either on a motion or on an appeal.
So any advice, I mean, either from your days of competing or of overseeing this for I don't know how many years now, of how do you get ready? I mean, even as a lawyer, right, you were just talking about being in the court of appeal. How do you get ready for those questions that are coming at you, the barrage from all the justices, or in a moot, the people that are acting as justices? Is there, something that you can share for students who are getting into mooting? Is there a way to be really effectively prepared for that?
Well, one thing is for people who are getting into mooting is that you always moot in pairs. There hasn't been a moot yet where people aren't mooting in pairs, at least at the undergraduate level. And one thing is very important is it's a team sport. When your partner is being asked questions, you should be writing those questions down. You shouldn't be dozing off, thinking about what you're going to do later, writing your to-do list, doing something else, doodling. It's a team sport. You should be trying to help, at least help and further around your partner. You should be preparing together. It's not a good sport for egoism. I'm great, and then I'll just pull my partner along. You need to be a well-balanced team. You need to work together. So that's important. In terms of thinking on your feet, I mean, it's something that's very difficult. I mean, I appeared at the Court of Appeal earlier this week, and I wasn't, happy at. I'm sure I did fine. I don't know, but the decision hasn't been released yet. But there's always, I think it was Winston Churchill said, there's three answers. There's, the answer you come up with at the time, which is like, okay. There's the answer you come up with 3 hours later, which is like pretty good. And then there's like the brilliant answer that you come up with in the bathtub 3 weeks later. And you're like, why didn't I say that? So you're never going to get there, and you're being hard on yourself if you can. But I think what you need to do is just learn to be able to think on your feet and to be able to answer questions the best you can, and be able to know your material, work with your partner, try and know the case as well as you can to be able to go to those aspects of the case that best answer the questions that the judges have. In mooting, it's especially, the judges are usually not subject matter experts in the area, as is in life. I mean, you're probably, appearing in front of judges who, if employment law, who didn't practice employment law, but they're now judging. Judges are generalists. So it does help you in terms of that you have to sort of educate them. You have to sort of figure out what their knowledge level is and then educate them, but then try and help them through the process. So mooting is very useful for that. But I mean, I just think it's important to engage with the questions. A lot of people want it to be Toastmasters. They get up, thank you, Your Honor, no more questions, please. If I could just read my script into the transcript, that would be great. It's just not helpful. You want questions. One of the things I would do when I was mooting, I don't do as much when I'm presenting in court, is I would actually gradually increase what I'm saying to sort of make it slightly more ridiculous, to force them to ask me a question. So, you sort of say, you're building an argument, and you want to build it in such a way that eventually they have to ask you a question, because otherwise you're just going to obviously win the case unless they disprove, unless there's a problem with some of your logic. You build 1 block, 2 blocks, 3 blocks, it's going up. So, you want to sort of build that logic, which you can almost get a feeling that, when you say a certain line, the judge is going to say, well, counsel, that couldn't possibly be true. Can you explain? You can invite the questions, and you actually want to invite the questions and have that conversation. If your judges aren't asking you anything in a moot, you're not doing well. Sometimes also in court, but sometimes if they ask you lots of questions. In a moot, if you're being asked lots of questions, it's usually better. In court, it could be really bad. But in a moot, they're usually comparing the teams that are in front of them. So you don't really win or lose. You can't, in a moot, you can't lose even though you were better just because your case is worse. It's supposed to be balanced. You take into account the case when you're judging. Someone with a much weaker case often does win a moot because they did better with a weaker case.
Great. Thank you for sharing all that. And thanks for, all the discussion here about starting a practice and employment law. I think there's a lot of very helpful information for all the students listening. So wondering, to wrap up here, Andrew, if you have any final words of wisdom for the law students or paralegal students who are looking to get into the practice, whether it's employment law or somewhere else, any parting words of advice? And thanks so much for joining us today.
Yeah, that's a good point. Well, just for anyone who's getting into the practice, I guess maybe just three general tips. The first is, if there's an opportunity to do something, say yes to trying to do it. If someone asks you to do something, say yes to trying to do it, and then figure out later how to do it. Or if someone needs someone in a group, be the person who volunteers to do it, even if you don't know how, and just figure it out. Ask someone else, spend the time to research it. You're only as valuable as you can train yourself to be. It's a personalized profession. So that's the first thing. The second thing is, make yourself invaluable to your business and or your boss. Number one reason why people are fired in this world, new boss doesn't like you, you're out. Number one reason by far. We do it all. We see it all the time. If you're invaluable to your company, you're invaluable to your boss, then they're going to keep you. They're going to promote you. They're going to be happy with you. That's how it works. I'm not saying walk into your boss's office every single day and say, how can I make your life easier today? It wouldn't hurt, but that should be kind of the attitude. How can you make the people who are responsible for hiring you, how can you make their lives easier? How can you be invaluable? If you were to leave, it's going to be a real problem for them. It's going to make their lives worse. Most people don't think like that. They think, what's in it for me? What am I going to get? Can't do that. We see people who are let go a lot, who haven't made themselves as invaluable to their company as they should have. Listen, if anything, people getting let go, it's good for me. But the fact of the matter is, it's better to not be in that situation to begin with. And third of all is, get a job, get in, do a good job, then negotiate. If you get hired, they don't know you from anyone else in the world, right? So if you come back and say, I don't like this, I don't like that, I need this. I'm not saying take every job that comes along, of course, if it pays way too little or whatever, that's fine. But we see people who are sort of caught in these circumstances. It's just better once you've proven your worth to then say, okay, now I want that raise. This is why I'm doing all these things for you. This is why it's, better. I am invaluable because I do this and I do that and I do this. So that's why I should get XYZ thing I want, or that's why I should get this other thing. So a lot of people spend their time being upset that they're not proactively being, handed things or given things. So it's important just to, get your foot in the door, do great work, and then move up. I think that's really important. I think it's important in every job, but especially in law, you really want to increase, your hourly rate, your billable rate, your value rate, the value proposition of you to the firm or to anyone else. So those are just, I guess 3 pieces of advice that maybe hopefully people will have as a takeaway.
Perfect. Thanks again, Andrew. Enjoy your weekend and all the best in your practice and beyond. And thanks for everyone for tuning in, and take care.
Thanks. Take care. Bye.